Uh, Hi everyone. It's bang 3 p.m. here, uh, and I'm happy to see all of you here to discuss, the SR judgment, which is kind of, a landmark judgment, as in it goes in all areas, all different areas that could be imagined. All right, let's start. So, welcome all of you to this webinar on analysis of the SR judgment and before and after of it. And for discussing this judgment, we have with us Ujjawal Satsangi, who is an advocate at the Allahabad High Court. He frequently appears before the NCLT in relation to IBC proceedings, and he also appears before the High Court in Allahabad. And he's also our faculty for the course on the executive certificate course on National Company Law Tribunal litigation, right? And Ujjwal has also addressed students of our Diploma in Companies Act, Corporate Governance and SEBI Regulations course when it comes to dealing with specific matters that are brought before the NCLT in terms of Companies Act as well as IBC. So welcome, Ujjwal.
Thank you, Komal.
Yeah. So just to give you, put you guys a little bit into the story in SR. So this isn't something that is just happened, right? Like SR Steel, everything started from the point when it was actually put into one of the 12 major defaulters, right? Which the RBI had identified for the purposes of kind of immediate bankruptcy proceedings, because these were the people who contributed to a huge amount of NPAs with the banks, right? So SR was one, JP Infra was one, Bhushan Steel was one. So if you can note, these are all like highly capital intensive entities, because the kind of debts that they have, the kind of massive amount of debts that they have, like it would kind of resonate only with a capital intensive entity engaged in steel, engaged in construction and the like, right? So SR Steel has had a history of all of different proceedings. It was put into these 12 defaulters, and it kind of claimed that it shouldn't be there. It should have been in the other list, which was given 6 months to to manage their debts for a period of time. It went into appeal in the Gujarat High Court after that, and then there were a series of proceedings before the NCLT and NCLAT, and even for, I think, once before the Supreme Court. So now this judgment kind of brings into position a situation where the resolution plan proposed by one of the resolution applicants, which is ArcelorMittal, in this case, can finally go ahead. Right, Ujjwal? That's how we can conclude this judgment?
Yeah, certainly. As you already put forward, that this is not the first time this matter has went to the Supreme Court, and even on the earlier occasion, when ArcelorMittal went to the Supreme Court challenging the order of the NCLT with persons of the order of under Section 29 capital A, that also was a very important and landmark judgment in terms of IBC. And now with this judgment, which has clarified a lot many points in IBC, and that is to a 3-judgment coming from the Honorable Supreme Court, that practically raised a lot many questions pertaining to IBC law.
Yeah, it kind of goes into the role of everyone sort of that would be involved with insolvency proceedings and dealing with the role of committee of creditors. It also get into the role of the resolution professional, kind of role of the resolution applicant, and most definitely of the NCLT and the NCLAT. So it goes into all different spheres of examining the roles of all of the parties who are involved with insolvency proceedings. So we'll begin with one of the prime parties here, which is the committee of creditors, right? And this judgment kind of definitive puts a definitive superiority, if you may say so, of the committee of creditors. How do you explain that, Ujjwal? So how do you?
So if we go by the reading of the Insolvency and Bankruptcy Code, it is the company operator which has been given most of the rights in terms of resolution plans, how to go about it, or how or what to accept and what not to accept. But the problem which has been, because this is a new area altogether, and the NCLT and NCLAT was still was not keenly taking the new legislation as they should be taking that into account. Therefore, they were trying, the adjudicating authority, which is the NCLT and NCLAT, were trying to find loopholes, and they were trying to show their superiority in terms of what to accept and what not to accept. Uh, if we go back a bit deep in history, we'll see that this point of law was earlier already settled by K. Shashidhar's judgment. But even despite that being done, we still had the NCLAT order in the Essar Steel's case. So again, the Supreme Court has taken the opportunity and they have described it altogether. What is the role of the RP? What is the role of the company of the committee of creditors? How to segregate the unsecured creditors and secured creditors, and how the resolution applicant should go about the entire process. So if we see from the perspective of committee of creditors, certainly this judgment has categorically stated that their commercial viewpoint is absolute, it is paramount, and nothing can change that. If they have said that they are going ahead with a particular resolution plan, then the adjudicating authority, that is the NCLT or NCLAT, doesn't have much to say about it. They only go by what the statute provides them to look into the resolution plan approved. Otherwise, there's nothing much which the NCLT or NCLAT can do in that.
Right, but it kind of said that, as you rightly put, that NCLT or NCLAT kind of cannot extend their adjudicative authority beyond, what, committee of creditors. And I think they also pointed out the fact that earlier there was a requirement for the committee of creditors to kind of have a majority of 75% to be in approval of, the resolution plan, and that was there is reason down to 66% through the amendments. So I think the amendments would also like challenged in by in this judgment by I think, and there were a lot of different advocates from the financial creditors and all big names, if you will see. So they are all from representing different financial creditors and operational creditors. So if you they also kind of brought this into the picture, that it was brought down for a specific purpose. So they have this sense, and they are not supposed to act in a fiduciary capacity, which is something which is like very nicely pointed out. They're supposed to act in a commercial or a business judgment manner. So would you like to say something on that? Like, it's very interesting that that's pointed out there.
So if you see the entire case itself, there are not only civil appeals coming out from the NCLAT order, but there are writ petitions clubbed with the in the process itself. So the writ petitions were there because the amendment section 4 and section 6 were under challenge, and their violations were challenged. That is why Mr. Tushar Mehta, the ASGI, also appeared in this matter and put forward the union's point of view with respect to those sections. Now, coming back to the first point, that the 75% and 66%, which you already pointed out, the Supreme Court has very categorically stated that this amendment which has been brought, which brought down the requirement of having the majority of 66% in order to approve a particular resolution plan by the COC. That is because it was considered by the legislator, and it was felt that the 75% requirement, which was earlier there, sometimes becomes practically impossible, it becomes redundant, and that was not actually fulfilling the entire process. The Supreme Court has in a very good manner, they have read the entire case with respect to the preamble of the IBC, where it is categorically been provided that the process, the intent behind IBC is to provide a some sort of future to that corporate debtor. It is not a process where it is not a process of recovering the money. It's a process through which you can revive the company in some manner so that the existing debt can be repaid off, and then the company can go ahead, it can generate more profit, more revenue, and then it can repay back the rest of the amount if possible, or it can contribute to the economy itself. So
Absolutely.
it is in that light they have read the 66% amendment, and they said that if we go by this intent, then having a 75% majority, which is sometimes becomes totally difficult to achieve, it is better to go with the 66% majority, because it is
Yes.
how
Yes.
the commercial intent is coming into place.
Yeah.
Similarly, they have again infused the same idea with respect to the superiority of the committee of creditors over the NCLT or the educating authority with respect to approval or disapproval of a resolution plan. But at the same point of time, because you need an NCLT, you need an adjudicating authority, they have also stated, because sometimes the commercial idea or the commercial plans or whatever wisdom they have, that might run contrary to the legal wisdom, which is already there. That is why they have categorically read that the judicial review provided to the NCLT, it is already there as section 30 subsection 2. So whatever it's there in subsection 30 subsection 2, the NCLT has the absolute power to check as to whether the resolution plan which has been approved is in consonance with these particular provisions or not. If that is not, then certainly they can remand it back to the COC to reconsider it. But so far as it is in consonance with 32, then the NCLT or NCLT does not have any jurisdiction to say, no, we believe that some other, the resolution plan is wrongly accepted, or it should be modified and altered. That is what has happened in this particular case, where the NCLAT and NCLT has modified the resolution plan. Whatever resolution plan was decided, they have modified it to a large extent. So to that extent, the Supreme Court said that that cannot be done. That is absolutely not the prerogative, the right of the NCLT or NCLAT to do so. That is the commercial wisdom of the COC, and they should have that commercial wisdom done.
Right. Um, Another connected aspect of this is, that they are saying that there's a difference between treating uh, creditors equitably, and there's a difference between treating them equally. So while the NCLAT judgment sought to have equality, it didn't seek to, the equitability part of it was something that the Supreme Court stressed and brought in. So equitability does not necessarily mean that everyone is treated or paid exactly in the same order, but it means that they're treated in a fair and equitable manner based on proper grounds. They still can be treated differentially. So would you like to dwell a bit on that, Ujjawal?
So that was a very wonderful part, and perhaps the biggest problem with the NCLAT order was this only, where they have said that the operating creditors and the financial creditors, or the secured or unsecured creditors, are on the same level, and they should be repaid in the same manner. That is where the scheme of IBC comes into play, because the scheme of the IBC itself, if we read section 53, it provides a categorical list that in what manner the repayment should be made. The first and foremost, it is the resolution professional that should be repaid off. Then comes the workmen who with 24 months experience, the secured creditors. Then comes the other workers, the unsecured creditors, so on and so forth. So if we read that, that means the code itself is saying that all of them are not equal when it comes in the pecking order. There is an order, and that's how they should be repaid. But to the contrary to that, we had the NCLAT order, where the NCLAT said that no, the creditors with more than 1 crore should be repaid 60% of their debt, and so on and so forth. You must provide these facilities to them and these facilities to them. That was absolutely wrong on part of the NCLAT to provide such kind of order, and that is where the Supreme Court has said that this is not how it should be done. There is a difference between equity and equitability. So if you see by the sense of equity, because what comes into play is Article 14, but then Article 14 also says that the bare reading of Article 14 says that if there are two people, both of them should be treated equally. So if we go by that logic, then certainly the financial creditors and the operational creditors should be treated equally. But the other part of Article 14, the jurisprudence of Article 14, which tells us that you can have a different setup for different class of people. So if there is one class, you can treat it differently. If there's another class, you can treat it differently. So here the Supreme Court said that the financial creditors are different class, the operational creditors are different class. There are subclasses into it. You can develop in the subclasses as well. When they are different classes, then having somebody above in the pecking order and somebody lower down in the pecking order doesn't make any difference. There is a legislation for that. The legislation has already provided the financial creditors over and above them. But when here comes the equity part, that because now we understand the scheme of IBC, the committee of creditors is a very special body where the voting right is only with the financial creditors. Even if the operating creditors are given a right to appear, even if you are having more than 10% as an operational creditor, even then they don't have the voting right. So that perhaps gives an absolute arbitrary power to the financial creditors that they can decide whatever they want, whatever resolution is going to favor them, they can very well decide, and that goes against the operational. That is where the Supreme Court has clarified that here comes the equity and equitable part, that whatever you decide, whatever resolution you decide, that should be decided keeping in account the interest of the operational creditors. And if you read section 30 subsection 2, because now if you read this with the judicial review part of the power given to the NCLT, even there under section 30 subsection 2, it is provided that the interest of the operational creditors should be secured with. So if there is a resolution plan which has been decided by the COC, and the interest of the operating creditors has not been secured in there, it is apparent that it has not been secured in there, then the NCLT has the absolute power to say, no, this is absolutely wrong. We are not going to accept this. You please take it back and review it once again. Then you cannot say that the wisdom of the COC is over and above the NCLT. At that point of time, the NCLT will supervise the COC. So that's how the equity and equitable parts come into play.
But what you said will go against the equitability as such, right? So, like, because if it is something that is totally against operational creditors, it is not equitable in the at all. So therefore, it will go against the equitability criteria as such. Funnily enough, it takes me back to a historical kind of mythological kind of situation where one of the people was, I think this is in Mahabharata, that someone was asked to make a judgment or give a punishment between Brahmin and Vaishya and Shudra and all of these guys, and they had all killed someone. So now they were given equal punishment, which is death punishment for all. And then someone said that no, it's the duty or the role of these guys who is to take care. So it will be different punishment. So I mean, when you were talking about the role of the different things, this is what struck me. But it also referred to other acts, as in it says that clearly there is kind of a priority of secured creditors, right? Usually these tend to be financial creditors, while operational creditors will generally tend to be unsecured creditors. And clearly, if you look at the scheme of other acts, like even Companies Act, and if you see provisions of charges and all, there is a tilt in favor of secured creditors there. So they obviously the intention is that because if it doesn't happen, then if they're not kind of treated on a different scale and they are treated just absolutely equally or at par with the unsecured ones, then they will always say that fine, let's liquidate the property, and because then we'll get it because we are secured creditors. So there won't be an element or interest in the revival of the company in that case. So that's why there's a support again in favor of differential or difference treatment, right?
That is another aspect to deal with, because you see another right which has been granted to the operational creditor is that the resolution plan must provide them the amount which they are supposed to get in the liquidation process. So the resolution plan cannot be passed in a manner where they are being if we see the process being that the IRP is appointed, he's been confirmed as a CIRP, then he does a valuation of all the assets and of the company. Once the valuation is done, at the same point of time, it is examined that uh, at what value the liabilities pertaining to the secured and unsecured creditors are there. So considering that, at that point of time, you get to know that, okay, this one particular operation creditor, his values is with respect to X amount. And if we go into liquidation, then we can realize Y amount. If Y amount can be realized, then the answer to that is that the resolution process, in the resolution process, the COC cannot pass a resolution where below the Y amount is being paid to the operational creditor. If that is the case, then then the NCLT can struck down that kind of COC's observation, COC passing of the resolution. Again, the difference treatment between operational creditors and financial creditors, or secured and unsecured creditors, there's something which has already been discussed in the Swiss Ribbon case and
Ribbon's
the
judgment,
Supreme.
absolutely. Yeah.
And the Supreme Court has relied heavily upon the Swiss Ribbon's judgment. And you need to understand that why the financial creditors have been given that supremacy over the operational creditors. Because you see, the operational creditors come into play because there was a financial creditor who invested in the company and the company started running. If the company would not have been running at all, then the operational creditors could not have come at the first place itself.
That's very interesting. Yeah.
So it is the first and foremost, it is the financial creditors' liability. It is their money. They have heavily invested in it, and their interest is much more larger than the operational creditors. What the other side of the argument is that the operational creditors are small people, and sometimes what happens is that if your 1 crore is there, you have given a loan of 1 crore to a particular company, there's an outstanding amount to the trade-off, and you're not able to receive it back. That would perhaps affect your entire company, your entire operation.
Absolutely, yeah.
And therefore, in that case, you have to see that these big companies, the SBIs and other banks and other financial sectors, they might suffer that loss. They might suffer 1 or 2 losses, but these small companies will not be able to suffer even a small loss. So therefore, you have to give some treatment to them. Some benefit has to be provided to them. That is what the IBC has been trying to do. And this judgment has categorically pointed out that even then, the equity and equitable preferences, which we just talked about, that comes into play. You just cannot oust them and their liability and their interest. Their interest has to be taken into care. But again, it is the financial creditors who say would come first, and then it would be followed by the operational creditors.
Right. Thank you. That was a wonderful explanation, Ujjawal. So the another thing that we come into is about the role of the personal guarantors, and that is much talked about, like after this judgment now. And the ANCLAD kind of, declared that this deed of guarantee is set aside, like once the guaranteed debts are paid, but Supreme Court thought otherwise. So would you like to discuss that a little bit?
So the guarantee part is another important aspect, where again the Supreme Court has went back to one of its own judgment of the SBI case, a recent judgment of 2019 itself. And there the Supreme Court has again said, because what happens with what the ANCLAD did, they said that the personal guarantees will continue. Now what actually happens is that when a resolution applicant has moved his application, he has gone through that what all debts are there, what all liabilities is he going to undertake. If the personal guarantees would supposed to remain to be continued even after repayment of the debts, then that will adversely affect the resolutional applicant itself. It's his own liability will come in, will be endangered. That is why the Supreme Court said that if the repayment has been made by this resolution, then the personal guarantees are gone. Then there is nothing called as personal guarantee left, subject to the pending litigation. The pending litigation would not be affected. That will still be continued. But if the resolution plan is addressing the guarantees which were extended by the directors, the personal guarantee, then it was no more accepted. It was you cannot again come back again say those no that personal guarantee will also be invoked. That has been now addressed with and that is done with. And even in that case, the Supreme Court has very categorically said that they are not pronouncing something uh, which is something respect to this particular case. They have tried
Ah,
to refrain to go much in detail about it, but they have given a passing reference to the guarantee.
yeah, right. Um, another aspect I think in this case is that uh, does it result in this the insolvency proceedings kind of going on beyond the 330 days? So like holding that, yeah, and because initially there was a leeway of legal proceedings that could continue and those were excluded. Then there were these amendments which said that no, like the legal proceedings also inclusive, and now everything is 330, and now this judgment again kind of says that no, it can go beyond 330 days in certain cases. So how do you interpret this part of it?
So you see, there are both good and bad things about it. The good thing being that sometime what used to happen that the 330 days were not enough to address the issue. Sometimes you felt like that almost you were there, you're almost reaching a point to resolve it, but you require a week or two more. But the NCLT was helpless in that manner. The NCLT was categorically helpless. The law was strict in that term that you have to complete it within 330 days. Again, here comes the preamble of the IBC. The IBC is not something which is not being brought to liquidate companies. It is not being brought to recover. It is not being brought to squeeze the companies up and take out whatever you can. It is being brought to ensure that the dues are being paid off and the company can run ahead after this process is completed. And if a 10 or 20 days grace period is allowing you to do so, or is allowing you to achieve it, then why not to do that? That is where the Honorable Supreme Court, referring back to several judgments, raising back to 1950s in different areas, they have gone to CRPC, they have gone to CPC, they have gone to Old Companies Act, and bringing all that jurisprudence into, they have said that the word mandatory, which was brought in by the amendment, they have struck down the word mandatory. They have said that it is not mandatory, but it is expected out of them that ordinarily within 330 days they need to complete it. Now, what effect it does, that, and again the Supreme Court has obviously remarked it in their judgment, that if the resolution can be completed in a very short time after 330 days, the NCLT can provide that particular time. This is the good part of it, that yes, you can now actually reach out to a particular stage and the resolution can be made. Not every company needs to go to the liquidation and all. But the other side is, which is the sad part, that this leaves, this creates a big scope of interpretation, which might linger on the entire process. And as on date, the condition was that if within 330 days you are not able to get a resolution, the company will go into liquidation. At least you will get something out of liquidation. You may not be getting what you were expected out of the resolution plan, but you will get something out of the liquidation plan. But here you can actually linger on the entire process. So from 330 days, you stretch it to 400 days, 450 days, 500. What is that short span of time? That is short span of time means 2 weeks, 3 weeks, 10 weeks. What is the short span of time? We don't know that. So that actually creates a hindrance and that creates a hiatus between the resolution plan and the liquidation stage. That would perhaps have a negative impact, but I'm sure even then a strict interpretation would be given to the word used by the Honorable Supreme Court, that is a short time may be granted, not a long time. So I believe you cannot expect a NCLT giving 330s more 330 days to that, but certainly we will get some breathing space would be given to the IRPs and the CIRPs
Yeah.
to resolve the process.
Like the SR one has gone for 600 days. I mean, that's what is indicated, I think, in the judgment itself, interestingly. And it's now that, they have reached this stage that, okay, the resolution plan can be implemented. So, I mean, imagine the proceedings as such. So, it's gone on for such a long period. And it's landed into a space only now that, okay, the resolution plan that has been submitted can be implemented. So, I mean, completely, you are very right, Ujjwal, that if it is interpreted on what is a short span basis, there can be issues on that. But again, it has to be taken on a reasonable ground, and it wouldn't go into 330 days more, or crazy periods like that. But yeah, so that's the time aspect of it. The other part of it is somewhere it has kind of drawn into the role of the resolution professional as well, saying that the role is to bring about it to the committee of. I think there is a discussion in the judgment about this, that the role is there to bring the resolution plan to the committee of creditors. Like, they only need to check that it's complete and complies with the code in all respects, and exercise a basic due diligence that is required to be done. But otherwise, they're not supposed to sit in judgment again on the resolution plan as such. So how do you take about this? Because here, interestingly, one of the parties is the resolution professional, by the way. The Satish Kumar is the resolution professional who's one of the parties. So how do you dwell on the role of the RP?
Supreme Court has again done that. They have read into the provisions of the Act. They have gone into Section 20 of the Act, and they have examined that the IRP is somebody who's there to facilitate the committee of creditors. The IRP is not there to put his mind or put his opinion. So if we, once the IRP is appointed, the IRP then, when it's been confirmed, the IRP does the evaluation. Then the IRP goes out, the IRP puts out the expression of interest. Then the resolution plans which he accepts. After having resolution plans, he examines the resolution plans to the extent to ensure the compliance of Section 29 capital A. That whether these particular resolution, the applicants are in compliance with Section 29A or not. Once that is done, that is the entire scope of the IRP and the CIRP. He conducts the meeting. He notifies all the parties for respect of the meeting. He prepares the entire documentation and everything, and then he presents the entire record before the COC. And ultimately, it is the COC which decides what to do and what not to do. In this case, what is important, what we need to see is that with respect to the COC, that moment 29 capital A objection which the IRP has raised, he can place it before the COC, but ultimately it is the COC which has to decide and undertake. So it is ultimately they have to say that what they have to say. So even then, his recommendation is not binding upon the COC. So this is again the Supreme Court has went back to the judgment of K. Shashidhar and Swiss Ribbons, where they have examined it earlier as well, that what is the role of the IRP. The IRP is only there to facilitate. And the IRP is not somebody who's going to say that, yes, I'm going to accept this and I'm going to reject it. It's ultimately the COC which is going to do it. The IRP is a bridge between the COC and the adjudicating authority sometimes, where if the COC refuses to appear before the adjudicating authority, the IRP brings their decisions before the adjudicating authority, and the adjudicating authority either stamps it or returns it back to. That is the entire scope which has been provided by the NCLT judgment, the Supreme Court judgment.
Yeah. The big role is to constitute the committee of creditors itself, and then the committee of creditors kind of takes over all of the things. So yeah, very true, Ujjwal, about that. So while we were talking about the ultimate decision of committee of creditors, there is also a situation here where the committee of creditors constituted a subcommittee, right? And this was what was kind of again questioned, that can you even constitute a subcommittee to deal with anything at all, and whether that is a valid or that is permitted to be done by the committee of creditors. So I think there's no express provision in the act which would allow the creation of, a subcommittee, and that kind of, raise these questions. So, what do you think about that?
So the answer to that lies in the very old jurisprudential question of power and delegation of power. So in that respect, what we need to see is that the power is with the COC to decide over a resolution plan. Can the COC delegate that? The answer is absolutely no, because there is no provision which enables the COC to delegate that particular thing to. But then, in order to exercise that power, there are a lot many work that is required to be done, and that is somewhere where you need not to have the entire COC to carry out that particular work. There, the delegation comes into play, where the delegation can be made to see what these things are. For example, to examine the records, to examine the background of the resolution applicant, to assess the resolution plan which he has brought forward. There are multiple aspects of the resolution plans. You might constitute the operating creditors committee, where you have 2 or 3 operating creditors more than 10%. You constitute a committee of them along with a financial item member to examine that, yes, whether this resolution plan is actually in consonance with your interest or not. So simultaneously, you can have an unsecured committee. You can have several different committees. These committees then decide and bring their opinion of whatever they have decided, their findings, before the COC. And ultimately, it is the COC which is going to decide that, yes, what needs to be done and how it needs to be done. These subcommittees do not have the power to decide that, yes, this is what we are deciding, and this is how we must need to go forward. In the same manner, where the IRP cannot decide, the IRP can only bring their findings before the COC. In a similar manner, the subcommittees can only bring their findings before the COC, and the COC will has the ultimate right to decide to say yes or to say no over that. That is what the Supreme Court has already said, that the creation of subcommittee need not mean that the entire process has lapsed or the process is absolutely wrong. The subcommittees can be made, but the power to decide still rests with the COC.
Right. Yeah. So they are supposed to basically analyze and report, kind of make a report to the committee of creditors, where the committee of creditors will be the ultimate decision-making authority. There's one more point in this judgment where it talks about adding any additional debts or any additional claims beyond the resolution plan, which is already kind of accepted or put through by the RP and taken over or brought through by and accepted by committee of creditors. So adding things to it, I think in a lot of different points, the judgment kind of points out where even NCLAT has added to the claims, or in some respects, that's what it points out, that it has incorrectly added to the claims or added to the debts of the creditors after the resolution plan was actually put through and approved by the committee of creditors. So what would you say to that? Now definitely, it would create a problem, because if it is not crystallized at that point of time and subsequently later things are brought in, then things will always be in a volatile state, and you will never reach a final state where a resolution applicant can get a full idea that, okay, full gamut, that this is the complete amount of debts and everything that is he needs to deal with in his proposal. So what do you say to that? Definitely that is something that should not have gone forward, or that should not have been taken. So how did the athlete land into that arena as such?
So to answer your query, the idea behind that rests in a very simple situation. You go to buy a land. I'm just giving you an example. You go to buy a particular land. When you visit the land, you see the land. You see what all buildings are there, what are boundaries they share, what is the scenery out there, and everything. And accordingly, you examine the evaluation. You see your interest, and then you decide whether to purchase it or not. The moment you enter into the process to purchase it, you have already advanced a certain amount. So you have purchased the stamps and do other things. You have invested some time into it. Then you have been told that you see what you all have seen, that is all fine, but there's an additional liability charge. So that is something which you have to take care of. We have some intruder in it, we have a trespasser in it, or something like that. There is a taxation matter which is continuing in this particular case, or something of that sort. If that is to be presented before a buyer, the buyer is not going to buy that particular property. Or why he is going to buy it? Because he thought, he examined his position after going into what all the things which are there and what he is going to enter into. Once he has entered into, then you cannot say that no, you have to take this as well. That is what has happened in this particular case as well. The IBC provides for a specific timeline. The company is declared insolvent. The IRP is instituted. He is been confirmed by the committee of creditors. He evaluates the entire property. He calls for the dues. He calls for the demands of different parties, of the operational creditors, workmen, the financial creditors, and everybody. Once he receives all these demands before him, he then prepares an expression of interest accordingly, giving out the entire liabilities, giving out the entire valuation of the assets and everything. And then somebody comes up and say that yes, I am going to buy this entire company, I am going to resolve this particular situation. Then he derives a particular resolution plan, which is then examined by the COC. Now, once this entire process has been done, or perhaps when the resolution plan is at the stage of consideration before the COC, or perhaps when the COC has already decided it, then you say, no, this is all fine, but there's this one extra 5,000 crore rupees liability which you need to address. We are giving you this as a gift. That you can't do. Especially 5,000 crore. That is exactly what happened in this particular case, where an additional 5,000 crore liability were being infused upon ArcelorMittal. That is something which is categorically a no from the Supreme Court, that this cannot be done. There is a time limit for it. You have to apply that time limit. You just because again the same idea, the same phenomena comes into play, that IBC is not something which is there for recovering the money. IBC is something which is there to facilitate the revival of the company if possible. Recovering the dues is the last part. There's the liquidation comes into play. But if the revival is somehow manageable, is somehow that you can achieve that, then we must go ahead with that. It is there the Supreme Court has said that these kind of backdate, these kind of belated dues, these cannot be accepted. The NCLT has no power to do that. The NCLAT has no power to do that. All the dues has to be placed before the IRP within the specific period of time. Then the COC will have to decide over the claims. And once the expression of interest has already come, once somebody has given you that yes, this is how I'm going to resolve it, then coming with an additional burden is absolutely wrong. That cannot be done. And certainly you cannot ask the such kind of resolution applicant to undertake those liabilities as well. That is what the Supreme Court has said, that no, this cannot be done. This is absolutely flawed in the face of it.
Yeah, I mean, if it were allowed, which resolution applicant will come forward, and because they'll feel that any time someone else can come and land additional dues after that. So like it will deter people from actually going for and taking over a resolution of any of the entities, and that will kind of bring most of them into liquidation and all. So yeah, that's very right, Ujjwal. I would like to share this judgment. Interestingly, it's such an interesting read for everyone. If you have, I would like to share that. I would like to screen share the judgment. So here it's over 164 pages. You can see how many civil appeals and writ petitions it deals with, right? And each of them has been, there's an order with respect to each of this in this judgment. So it's a very interesting read, right? The parties here are obviously the Committee of Creditors of Essar Steel India and Satish Kumar Gupta and others, who is the the resolution professional. Yeah. Anyone has any questions so far? People are kind of silently listening. Any questions or any interesting things that you want to draw? Just look at the amount of civil appeals and writ petitions it has in this. And if you read the arguments by by the lawyers, interest, you will be kind of drawn to think that okay, this is so right. Like it will become very difficult to arrive at and say, okay, now this representative or this lawyer is totally against IBC or something like that. It would kind of land you into a situation where you will think that it's a convincing argument. So it's very interesting to read.
You just read what Mr. Kapil Sibal has said.
Absolutely, yeah. Like Kapil Sibal is the one, and who's been opposed by even other lawyers of there, and just on the grounds that it can't stand at all in all his arguments. But it's very interesting to read. In fact, the claim by one of the lawyers. Let me bring it down to that, where he says that. Having the business continued, of the corporate debtor is of paramount importance, and like the interest should be that the business continues so that people are able to, the corporate debtor is ultimately able to pay back. Let me bring that down to that claim. It is a very interesting read. I think it's way down somewhere. And these are all each of the different advocates on behalf of financial and operational creditors. There's someone on behalf of the Gujarat state as well, I think. This is Harish Salve. No, wait, let me come to that. It's a very interesting read, guys. Like, read and you will enjoy, if I must say so. Like, it will even put you to think what kind of arguments actually go on. Here it is. Ranjit Kumar on behalf of Ideal Movers Limited, right? And his statement is that key objective of the code is to ensure that the corporate debtor goes on doing its business as a going concern during CRP, as a result of which large number of operational creditors have to be paid their dues. So, like, if the business of itself of the corporate debtor is affected, then how is it going to ensure payment of the dues? Okay, and the CRP has to ensure balancing of interest of all stakeholders, which can only be achieved by a feasible and viable resolution plan. The process of revival and liquidation are distinct and separate, exactly like how Ujjawal you pointed out. So the priorities which apply in a liquidation cannot apply when the corporate debtor is being run as a going concern. The intention is that it actually generates revenue. It continues to go on as a business. Okay, it's to maximize the value of assets of corporate debtors. Okay, whereas liquidation process is to recover outstanding dues. So, like how you pointed out, it's not a recovery proceeding, but it's to maximize the value. Interesting reads here by different advocates. Anyone has any questions on this judgment or anything that struck you which you want to ask Ujjawal about or discuss? There's even a representation, I think, a writ by one of the operational creditors who is itself into liquidation or in NCLT proceedings.
There were quite a few writs by different parties, like the Gujarat, which had filed a petition, and then you have different operational creditors as well. But the bottom line of this particular case goes down to the fact that how beautifully the Supreme Court has read the preamble and then corresponded to all the sections of the IBC code. And perhaps that's the beauty of this judgment, that it has given the what's the soul of this particular law, what actually we are trying to achieve from this particular
Yeah.
code or this particular law. That more through the procedural aspect, because we already had Swiss ribbons, we already had Shanivasan, Shashidhar, and we already had SBI judgment. So practically these things were covered, but with the intent that has now been brought behind the entire idea of IBC, that is the beauty of this judgment, and that's where this judgment is one of the finest till date. And perhaps the effect of this judgment can be seen in the market as well. After this judgment, the secured creditors and how the market has responded to their shares, to the banks and their shares, that goes to show that how well this judgment has been taken by the people at large.
Anyone has any questions on the points in this judgment, or what's going to change after this rather? Harsh, Manish, anyone has any questions? Anything that strikes your into your mind, even the feedback that you have in relation to the judgment? We have a few minutes left into the session. If you would like to share. None. Ujjawal, do you have any final, like you already kind of made a statement that it's a beautiful judgment in terms that it kind of establishes, the situation or the preamble of the code very nicely. Any final remarks that you would like to make? And we have just, a couple of minutes into the session, few minutes.
Well, the judgment is absolutely fine. It's a 3-judge bench judgment which clarifies a lot many points, and again reiterates what has already been decided in several Supreme Court judgments. And perhaps I'll take you back to the preamble itself, that the way Justice Nariman has read the preamble along with all the provisions, be it section 15, be it 18, to everyone. He has read the preamble with respect to everybody related to an IBC proceeding, be it the resolution professional, be it the committee of creditors, be it the operational creditors, or the secured and unsecured, and the financial creditors, the NCLT and the NCLAT. He has read everyone, and he has categorically denoted that it is where you have to understand this law from. This is the place where you have to understand the law from, and the law's intent is quite clear. We want revival, we do not want liquidations. And again, if you see the judgment, somewhere in the judgment, they have actually went into the report which was tabled before the Rajya Sabha, and Mr. Sibal opposed that particular reference to be made. To that effect, again, the Supreme Court said that this is something which is there on record. What the IBC is trying to achieve, it is already there, and we cannot deny that. And considering that aspect into taking that into account, I believe this judgment is very beautiful, and we all must go through it, because it's going to have a large impact, a huge impact on the ongoing proceedings, especially when it comes to the expansion of time from 30 days and beyond.
Yeah.
That is going to have a very big effect, and there is only one flaw which I find, that expression of short period of time, that can create havoc, and we probably might see another judgment coming in near future giving a restrictive meaning to what has been said in this particular judgment.
Yeah. Or defining maybe what's a short period or what can be considered what's reasonable.
Correct.
So, great. Thanks a lot, Ujjawal, for sharing your insights. It was wonderful. I will recommend, if you, if you guys actually, there can be lots of things that will strike you when you read that. When you read the judgment, there's very interesting things that will strike you. Like if you read it from a purely commercial perspective, also there are lots of things that will strike you. So go ahead, and guys, even if there are any questions, we have Ujjawal here with us. Relay it to us, and we will try to answer these to the best extent possible. Thanks a lot, everyone, for joining in. Thanks once again, Ujjawal. And
pleasure was entirely mine.
Yeah, have a great evening.
Same to you all.